name is Erin Coos. I'm a member of the team of labour and employment lawyers at Sherrod Coos, the Employment Law Alliance member firm in Toronto, Ontario, Canada. I'm joined today by my colleague Shayna French, also from Sherrod Coos, and by Amy Bradbury from the ELA member firm representing Canada's Atlantic provinces, Bartow Durnford. Issues of workplace violence are garnering more and more attention in almost every jurisdiction across the globe, including in Canada. We're here today to talk about some of the issues surrounding workplace violence from a Canadian perspective. Shayna, why don't you talk to us about the legislation in Ontario that deals with workplace violence issues, and then move westward?
The relevant piece of legislation in Ontario is the Occupational Health and Safety Act. That was amended in 2010 as a result of a number of serious and high-profile workplace violence incidents that resulted in fatalities. So our legislation has implemented a regime requiring risk assessments, proactive response, and annual review. Part of the policy requirements for employers when it comes to workplace violence, threats of violence, harassment is also covered in that, is to implement a policy and to ensure their workplace is compliant with the policy and educated around the policy. The sanctions for non-compliance when it comes to occupational health and safety go from fines and provincial convictions through, if it's egregious enough, criminal code sanction, which could be monetary penalties, but it could also be jail time. That's for companies in terms of the monetary piece, but individual supervisors are accountable and potentially liable as well. So in the Ontario regime, they take it very seriously, and there are many onerous obligations for employers to ensure that they're complying and, as I said, proactively addressing the potential threat for workplace violence.
So is dealing with that from a health and safety legislation perspective consistent also across Western Canada?
No. So in each province, we are seeing it being addressed, whether it's by the way adjudicators are treating the interpretation of an employer's obligations, or more particularly in the workers' compensation regime. So employees who are the victims of workplace violence are being compensated and being provided with income protection, and that is effectively a sanction for employers. So they are going to want to be proactive and ensure that workplace violence isn't a risk. When we talk about Western Canada, we're talking about 4 provinces and 3 territories. So things are going to change location by location, and that's important for an employer to be cognizant of when they're trying to identify what kind of policies they want to implement across Canada. There is a small group of employers who may also be affected by our Canada Labour Code, which is a specific federal piece of legislation unique to a certain type of business that does have obligations for workplace violence.
Okay, so let's talk about how those are being managed from a legislative perspective in the Atlantic provinces. Amy?
Okay, well, in Atlantic Canada, the legislative provisions are not as extensive as they are in Ontario. And in actual fact, in New Brunswick itself, there is no workplace violence specific legislation. There is only the general obligation to provide a safe workplace under the Occupational Health and Safety Act. In the other 3 Atlantic provinces, Prince Edward Island, Nova Scotia, and Newfoundland, the setup is pretty much the same. Employers are required to do a workplace violence assessment and then develop a workplace violence policy and program for their employees and to train the employees in it, and also to report and monitor any incidences of workplace violence. In Nova Scotia, there's one other sort of twist on the legislation in that it doesn't apply to every employer. It only applies to employers in certain industries. So things like retail, healthcare, corrections, education, where they found there's a higher incidence of workplace violence, they have those legislative requirements, but other employers do not. And again, they just fall back to the basic requirement to provide a safe workplace under the Occupational Health and Safety Act.
Oh, that's interesting. And has that been interpreted as implicitly requiring employers to protect from workplace violence, or is that still an open question?
It's a very open question. It's not an issue that has been adjudicated. As lawyers, as we tell our employers, they have that obligation to provide a safe workplace, and it would include the requirement to make sure there is no violence in the workplace, obviously, but it hasn't been applied or addressed by our legislative or by our adjudicative bodies.
Oh, that's very interesting. Shayna, we're going to go back to you. Labor arbitrators in a unionized setting often have to deal with discipline or discharge issues that arise from incidents of workplace violence. So how are they approaching these issues that might be a little bit different?
Adjudicators are taking a case-by-case approach when it comes to workplace violence. So it's all very context-based in terms of what was the circumstance leading to the incident, what's the employee's work history, discipline record. So it's not a presumptive discharge for every situation of workplace violence or threats of violence. An employer is going to have to make sure that they've dotted their I's and crossed their T's on doing an investigation around the violence. And when it comes to upholding a discharge, arbitrators also look at the post-termination conduct of the employee. Was there remorse? Have there been medical records introduced which demonstrate that the employee had some sort of mental health condition or a situation which triggered their reactive behavior? So arbitrators are very much keeping it still in the context. It's not going to be every instance of one employee pushing another on the plant floor that's going to trigger or uphold a discharge grievance.
So Amy, why don't you give us an example of how these things have been dealt with from an arbitration perspective in Atlantic Canada?
Well, we had a case a couple of years ago, and it involved a 15-year employee who also happened to be the local union president. And he met with a coworker one evening to pick up a grievance that was being filed. And for reasons that were never explained in the arbitration, the griever reached in through the open window of this woman's car and pushed her head forward towards the steering wheel. And she filed a workers' compensation claim and underwent 35 physiotherapy treatments for whiplash-type injury. So he continued to deny that it happened all throughout the hearing, and the arbitrator found that he wasn't credible in his denial. And even though he had 15 years of service and a clean disciplinary record, the arbitrator terminated him and said that it was unprovoked and it was an assault on a female coworker, which he happened to supervise as well. But I think the key to that arbitration was his ongoing denial and his inability to apologize or show remorse or accept responsibility for his behavior, and his termination was upheld.
So consistent with what Shana was saying, they're going to look at what he does or the perpetrator does post-incident, and if they come to the arbitration showing remorse, saying they understand the error of their ways, it's still not a slam dunk even in a serious situation.
I think that's true. I think a long-term employee who does take that responsibility would have a much better chance of being reinstated than an employee who continues to completely deny that anything happened.
Absolutely. So we're going to stick with you for the next question, Amy. What 3 tips do you give your employer clients when they're having to address issues of workplace violence?
Well, the first and I think the most important tip, particularly where we represent clients from a number of jurisdictions, is to make sure that the employer is complying with the laws that exist in the jurisdiction they're operating. As we've talked about, it varies from province to province what the requirements are, and Ontario is probably one of the more onerous provinces in terms of what employers have to do. So I think that's very critical that you make sure you're looking at the legislation that applies and that you're complying with that. The second tip that I give employers is to have a workplace violence policy, even if your legislation doesn't require it. And it should set out the responsibilities of the supervisors and employees. And it's very important that everyone is trained on those responsibilities so they know what's expected of them going forward. And finally, I think the probably other really important thing is that employers don't let things fester, that they deal with situations as they arise. They don't say, oh, that's a minor thing, it doesn't matter. These things can escalate really quickly, and so I think it's important that things are addressed as they arise.
Thank you. Shana, did you want to add anything to that in terms of additional tips?
I echo Amy's comments. The other element is apply it consistently. So ensuring that an employee is not being treated differently in terms of the accountability for their conduct from someone that maybe is more well regarded by management, because that's often one of the vulnerable pieces for employers is if they have not taken that same situation to an investigation and to a discipline stage with another employee because they dismissed it as horseplay or as playfulness, and now they are treating it as workplace violence. So ensuring employers are being consistent in their application of their policies and programs.
Terrific. So we're going to finish off by asking you, Shana, what tips would you give an employer from outside the Canadian jurisdiction in terms of establishing operations in Canada and dealing with these issues?
What surprises a lot of clients we work with is to learn that in Canada, each jurisdiction has its own laws, and that includes whether it's wage and hour, occupational health and safety, employment and termination entitlements, labor relations regime. So know, as Amy said moments ago, know the laws of the jurisdiction in which you operate. And that's the great thing about the ELA, is that we work with employers across Canada to provide them with the guidance and support they need to implement effective policies and make sure they're ahead of the game, so it's not reactive crisis management, it's proactive moving forward.
Thank you, and thank you both very much for joining us. This has been an incredibly enlightening discussion, and I really appreciate your time. And thank you very much for joining us.